I don't care. I don't care. You are literally in the middle of a plea and sentencing. You are not showing respect to your client. You are not showing respect to the court. You are not doing your job. We will go on the record in the matter 23 FA 63 in re the support or maintenance of CJT. Appearances are we do have Shannon Tretzman appearing in person without counsel. We have Corporation Counsel Stephanie Thomas Schmidt. We're set here today in this matter for a sanctions hearing. Mr. Tretzman was found in contempt for failing to pay child support. He was set on a purge order with purge conditions. There's claims asserted by child support agency that Mr. Tretzman has not met his purge conditions. Mr. Tretzman, do you understand you have the right to have an attorney?
Okay.
Yes, you would have a right to have an attorney. And so you can retain your own attorney, private attorney for this matter if you wish. If you do not, if you qualify for a public defender, you may be able to get one appointed to you. So for today's purposes, you are not with an attorney, so you're representing yourself?
Okay.
Okay, is that a yes, you are?
Yes.
Okay, so Ms. Thomas Schmidt, can you please update the court and let me know what it is you are seeking?
Yes, Your Honor. By way of background information, Mr. Tretzman is on, frankly, a pretty high order. And since this purge began, he's made some payment almost every month. There's the month of June that we didn't receive a payment, various amounts. He's approximately $2,200 short on what his total purge would be, which is why we're bringing this action. It looks like there was an involuntary intercept at one point, which helped catch some of that up from taxes, if I'm reading this correctly. But Mr. Tretzman has made, I'd say, a decent amount of effort. He's not all the way across the finish line yet, but I think we're on the right track. And so my request is to continue the purge for another year. And this has been discussed with Mr. Tretzman before, but the child support agency and myself, and I would hope the court strongly urge Mr. Tretzman to fill out the paperwork and file for a modification to review what the order should be set at given his actual earning circumstances as opposed to information that we had when it was set some time ago that ended up not panning out the way it was conveyed that it was going to.
This is a weird case all around. I knew I recognized Tretzman without, and I knew you were here for the child support sanctions and those types of things. But then I'm like, Tretzman, this is that weird motion to void marriage issue and how that came in front of the court. And so quite honestly, I don't recall where the custody, the placement, the matter is. Do you currently have placement of the child?
I was granted shared physical placement. Lately, it's been extremely difficult to see her. She's in therapy.
How old is the child?
She's 9.
9.
She's 9.
She was younger. Okay, so with that, do you understand what Ms. Thomas Schmidt is
Yes.
asking or saying?
Yes, I understand. Jody and I had a conversation. She explained it further.
I mean,
Now
I can explain
understand.
it to you. I can tell you, I can't give you legal advice. It's on your
Yes.
shoulders to file, to not file, to
Yeah.
research, to not research, to do those things. But it sounds like child support and Ms. Thomas Schmidt, like Jody and Ms. Thomas Schmidt understand the situation and where it was originally ordered and where things may go, or it may go a different route, but nothing can happen until you actually do something.
Right, file for modification.
That, and that's on your shoulders.
Okay.
So right now, what Ms. Thomas Schmidt is asking is, we have to continue as what the order was initially ordered.
Mhm.
And you have to meet those requirements. If you don't, you could go to jail.
Mhm.
So she's asking to extend the purge for another year, to continue the way it is, for you to purge yourself from that contempt and any of the sanctions. But in the meantime, you figure out, I mean, you can continue with this order if that's what you wish, or you can have the court review it and review all of your information to determine whether or not there has been that substantial change in circumstances and go from there. So.
Could I ask a question,
You may.
please? I didn't understand that last part. It sounded like there are two options.
Well, you can either continue exactly how it is right now and pay the child support what it is, meet the purge conditions, or you can have the court review it and review a modification request.
That's the modification process.
Correct.
Okay.
But I can't do anything unless you
I
ask
do.
the court to do something.
Okay.
So that's where that is. So do you agree right now to extend the purge, to continue with that purge for an additional year, if or until the court determines something else?
Yes.
Okay. So, Ms. Thomas Schmidt, the court will grant your request as stated on the record. And I guess we'll just wait and go from there.
Okay. And Your Honor, I'll ask that continue through July 31st of 2027. And for Mr. Tretzman's knowledge and for the court's knowledge and approval, the language of the current purge specifically says the dollar amount. I would be changing that to pay your support as currently ordered, such that if it goes down at a review, the purge amount would go down as well.
All right. How much is in arrears right now?
$5,863.12.
And so, Mr. Tretzman, that can't be reduced or wiped out or anything. The only way it can be is if Ms. Fountain agrees to do that, because the longer you continue to get behind, the longer or the more that this is going to build, and you will owe it forever until it's paid off. So where you live in Danbury?
St. Croix Falls.
Okay. And what is it that you do for a living?
I'm picking up carpentry work now.
Oh, excellent. Okay. And so you do that all by yourself? You do it as a sole proprietor?
Yes.
Okay. All right. So you don't have a set dollar amount an hour, or it's just per project?
Correct.
Okay. All right. So you're going to have to figure out, and that makes it a little bit more difficult when filing for a modification request, because you're going to have to produce financial documents, financial records for not only for my review, but child support, all of those things, such as tax returns and those kinds of things. Okay. I don't think we have to set another date or do anything like that.
No, I'm not requesting that.
Okay. All right, then we're good to go. Thank you. How do you get so tan? We're adjourned. How do you get so tan while building carpentry?
I had to give up on excavating. I can't take heat anymore. I've been sick.
This is
So
a hot
I've been
summer.
sick so many times this summer. I missed work on Monday. Sick. Yeah.
That's not good.
Not making excuses. I just.
Nope, I understand. It's been a good summer if people are
Oh,
on the water all the time.
If you're on the water, in the water.
Yep, exactly.
right.
Okay.
You're good to go. Stay in touch with Jody
Okay.
if you have any questions,
This
okay?
is the paperwork that I need.
Yes,
Jody?
yep.
Thank you very much.
You're welcome.
You're on.
Ms. Pulaski. We will go on the record in the matter 24 FA49 in re the support or maintenance of SDP. Appearances are, we have Ms. Pulaski, Regina Pulaski appearing in person without counsel. We have Stephanie Thomas Schmidt appearing for Corporation Counsel. We're set today for a motion hearing for sanctions, a request for sanctions. Ms. Pulaski was found in contempt and placed on a purge order. There's allegations and claims that she has failed to meet that purge. Ms. Pulaski, do you understand you have the right to an attorney?
Yes,
And you're going to be representing yourself here today?
yes,
And do you understand why we're here?
yes.
Ms. Thomas Schmidt, please update the court and let me know what you are requesting.
Yes, Your Honor. Ms. Pulaski's been on a purge. Her order accrues at $803.29 per month. Her purge is established at $500 per month, taking into account the amount of her accrual versus what she reasonably would be able to pay. Ms. Pulaski has been making payments, not necessarily full payments, but she's been making payments at least since she was given an imposed and state sanction in April. She did bring in a payment today that brought her purge current through the end of July. So I give her a lot of credit for that. Our request is to continue the purge, and that Ms. Pulaski strongly consider the same review papers that we spoke about with the previous gentleman, for the same reasons. And that Ms. Pulaski either file her taxes or provide verification that her taxes were filed. If we could verify a mailing address. My understanding is Ms. Pulaski is working at 10th Hole Bar. I don't know if it's mostly for tips or if it's something slightly more under the table or what the situation is, but 10th Hole Bar is not honoring a withholding. So if Ms. Pulaski would continue to self-pay and just provide verification that she's remaining working, since they're not doing that. And the standard contact provisions, notify of any changes in address, employment, etc.
All right, Ms. Pulaski, do you understand what Ms. Thomas Schmidt is asking?
Yes,
And she would like to extend the purge for an additional year. Are you okay with that?
yes,
And are you still at 10th Hole?
yeah,
And I know that you're trying to find other work or do other things, but it's been a little bit difficult.
yes. I do have check stubs somewhere, I think maybe,
Okay.
that I could bring in.
Okay.
And I thought I did turn the paperwork in, but I might not have.
Nope.
I don't have any paperwork
Okay,
filed.
So the paperwork I'm talking about, Your Honor, is the request for the child support to review it and then bring the motion saying this is what we think the order should be amended to.
All right, sounds good. She's within the time frame where she can ask for a child support review?
Yes.
Okay, and I know, I'm gonna tell you, I have seen you at your ups, I've seen you at your downs. But to me, right now, you're doing good.
Right.
You're working hard. She not only here as she now
Mhm.
brought her purge current, which I'm so proud of you. You are working hard. She's done the same thing in other matters where she's needed to pay money, and she's there and she's putting in the effort and she's doing what she needs to do. And
it's hard.
it is hard. And you're doing it all by yourself, Ms. Pulaski, which makes it even harder. You have to keep it up because you're doing great and you're doing it for your kids. And I know that this isn't the case to talk about it, and you don't have to say anything if you don't want to, but to me, you look good. You look so,
Well, thank you.
so. Are you doing good?
I've been doing very good.
How long have you been sober?
I think like 6 months now.
Because you do, you look good. You may feel a little down because it's hard and you're struggling, but you're putting in that effort. Yet you almost, or you cleared the purge, you cured it through July. You did what you needed to do. You were behind a little bit.
I think that was when I went to jail and I had to bail myself out. That's why that $500. I was behind, I believe. That's why I missed that month's payment.
Let's not go to jail anymore.
I know.
All right, but you're doing good and you're working hard, and I can see it. Ms. Thomas Schmidt can see it, so can Jody. You're doing what you need to do. Okay, keep it up.
Thank you.
If you're feeling the stress and you're feeling the pressure, reach out to somebody. Don't go down that other way. Okay. All right, so I'll extend the purge and
And I'm living with my uncle again at 4727 Gasoline.
4727 Gaslin. No.
Yes.
Okay, well, good. That'll help give you a little bit more stability too.
Right.
Anything else, Ms. Thomas Schmidt?
Just extending through July 31st of 2027.
Yes, that works. The court approves. Keep it up, Ms. Black.
I guess if I'm trying to think how to phrase in the order such that if Ms. Pulaski does submit the review paperwork and her order is lowered below that $500, that her purge would be whatever that lower amount is.
That won't pay off my arrears, will it?
No, but we're gonna focus on getting you current and doing what you need to do now so that it doesn't grow, and then we'll start looking at adding arrears payments.
Okay.
And I think you said it pretty well, and how you need to say it in order, just,
Right.
touch it up a bit.
Mhm,
But I understand exactly what you're saying, and I think Ms. Pulaski does too.
mhm.
So,
Yep. So if your order goes down to 400, your purge would then be 400.
Right.
I mean, you can keep
You
paying
can-
more.
Yep,
Right.
absolutely, and start
Already
chipping away at
paid.
the arrears, but I don't want you to be put in an
Just give me a moment. Has the district attorney seen these?
I just gave them to
Okay,
him as
thank
well.
you. It'll just take me a moment to read through these letters. Mr. Benson, I am reading these letters, but was anyone going to do any character reference in words, in oral?
Yes, everyone here would speak on her behalf. I assume the court would allow whatever it would allow.
Well, if everyone is, it's going to need very short and brief, but yeah, because there's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 people. Do you want me to read the letter that she wrote?
You have that, Your Honor, in case she's unable to read it herself.
All right, I do have it.
It's going to be emotional, Your Honor, obviously, so.
We will go on the record in the matter 24 TR 115 25 CF 46, State of Wisconsin versus Cindy Patra. The state appears through District Attorney Kevin Schmidt in person. Ms. Patra appears in person with counsel Adam Benson. We're set today in this matter for a plea and sentencing. The court has received and fully reviewed 4 written character reference letters. The court has also received and reviewed a letter written by Ms. Patra herself. She may be able to state that out loud to the court. If not, the court has a copy of her statements. The parties have reached an agreement. Mr. Benson, can you please recite the agreement for the record?
Your Honor, she would enter a plea to count 1. Count 2 would be dismissed and read in, and we're looking at the statutory minimum, Your Honor.
Ms. Patra, is that the agreement that you've reached with the state?
Yes, ma'am.
And I
Yes,
do
Your Honor.
note that there are 10 people here that are observing and watching this hearing. They are here for your support, and I do want to commend them for being here today. I don't see a lot of people supporting individuals who are entering pleas. Not as much as I should. And so that shows me, Ms. Patra, you are very loved and respected in the community. And so I appreciate that they are here. So I have in front of me a plea questionnaire waiver of rights form. Do you recognize this document?
Yes, ma'am. Yes, Your Honor.
Did your attorney go over this document with you?
Yes, Your Honor.
Did he essentially go over it with you word for word?
Yes, Your Honor.
And so do you understand everything on this document?
Yes, Your Honor.
Is that your signature on the second page?
Yes, Your Honor. Yes.
Ms. Patra, you are pleading guilty to an OWI 5 or 6. You are 56 years old. You have 12 plus years of schooling. You can read, write, and you understand the English language. Is that all correct?
Yes, Your Honor.
Did your attorney thoroughly go over with you what the state would have to prove to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
Did your attorney go over with you the maximum possible penalties you face as well as the minimum possible penalties you face?
Yes, Your Honor.
You are not receiving treatment for a mental illness or disorder, but you have had medications, but no drugs or alcohol. Is that correct?
Yes, Your Honor.
The medications that you have taken, are they any medications that interfere with your ability to comprehend or understand what's going on?
No, Your Honor.
So you're in a state where you fully understand what is happening and you're able to comprehend everything.
Yes, Your Honor.
Because you're charged with crimes, you are entitled to constitutional rights. Each of those rights is listed on the first page of this plea questionnaire. Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes, Your Honor.
Do you understand you will no longer have the right to a trial? You will no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you.
Yes, Your Honor.
You will no longer have the right to testify on your own behalf or remain silent and not have your silence used against you. You will also no longer have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you will no longer have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up here today?
Yes, Your Honor.
Do you understand that you're pleading guilt, that if you're not a citizen of the United States, your plea could result in your deportation? I have to ask that to everybody.
Yes, Your Honor.
Do you understand that you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
Yes, Your Honor.
You will no longer be able to vote in any election until your civil rights are restored.
Yes, Your Honor.
Do you understand the state would have to prove on or around December 19, 2024, in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant, a Class G felony? Do you understand what the state would have to prove?
Yes, Your Honor.
Do you understand the maximum possible penalty could be a fine of up to $25,000 or imprisonment of up to 10 years or both?
Yes, Your Honor.
Do you understand that there is a mandatory minimum sentence where the court shall impose not less than 1 year and 6 months for the initial confinement of the sentence portion?
Yes, Your Honor.
Do you understand that there is another part of the sentence which would be extended supervision?
Yes, Your Honor.
Do you understand that in certain circumstances, but not in many, the court may impose a term of confinement for less than the mandatory minimum if the court receives information that the best interest of the community will be served and the public will not be harmed? Do you
Yes.
understand that?
Yes, Your Honor.
Do you understand that there is an agreement that has been reached between the parties, and that is a recommendation to the court for mandatory minimums?
Yes, Your Honor.
Do you understand I am not bound to follow that?
Yes, Your Honor.
Said differently, I could sentence you all the way up to the maximum possible penalty if I thought it was warranted.
Yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
Did you go over the criminal complaint, that original charging document with your attorney? It has the facts that basically say what happened that day and why you were charged with the crimes.
Yes, Your Honor.
For the most part, are those facts accurate?
Yes, Your Honor.
Admitting here today, you in fact did operate a motor vehicle while under the influence.
Yes, Your Honor.
Are you stating here today that it would be either your 5th or your 6th conviction?
Yes, Your Honor.
Are you pleading guilty to this offense because you are guilty?
Yes, Your Honor.
Mr. Benson, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you, Ms. Patra, for you to plead guilty today?
No, Your Honor.
You're doing so freely and intelligently. That means you are telling the court you fully understand what you're doing
Yes, Your Honor.
and voluntarily.
Yes, Your Honor.
Has your attorney represented you competently?
Yes, Your Honor.
Has he answered all of your questions?
Yes, Your Honor.
Has he looked at this matter thoroughly?
Yes, Your Honor.
Has he looked at the discovery, the evidence in this case, and discussed it with you?
Yes, Your Honor.
Has he discussed with you whether or not you have any legal defenses?
At this moment, The judge makes the legal stakes extremely clear. Shannon Tretzman is being reminded that the existing child support order remains active unless he takes the proper legal steps to request a modification. The court explains that simply having financial difficulties does not automatically change a legal obligation. A formal request and supporting information are required. At the same time, the court recognizes that he has been making efforts and that the situation may require a practical solution rather than only punishment. The judge explains that failure to follow the purge conditions could potentially lead to jail consequences. Do you think courts should focus more on punishment or creating a realistic path for people to become compliant? The hearing now turns toward whether continued opportunity
Before I
will work.
proceed.
No, Your Honor.
As to count 1, OWI 5 or 6, a class G felony, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I will find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be merged and dismissed with count 1. The TR matter will be dismissed and read in. A judgment of conviction will be entered today. Mr. Benson, before we proceed to arguments, how many people will be making a statement on Ms. Patra's behalf?
I would have to, I assume all of you would, or
Whoever will be making a statement, please come up and sit in the jury box. You will have a seat right here in the witness stand, and you will provide your statement to the court. All right, sir, you're last or you're first? So just come right up here. All right, when you are seated, you can come in here. Nope, right in here. You should be able to open a door. And then have a seat. Speak slowly into the microphone and enunciate your words, please. First, state your name and your relationship with Ms. Patra.
My name is Mark Flom. I work with Cindy at Parker. I am the manufacturing engineering manager at Parker.
Can you spell your last name?
FLOM.
All right. What would you like the court to be aware of?
First and foremost, Cindy is a highly accountable person, both at work and outside of work. She has a huge heart and does everything she can to help everyone at our Parker facility. We had 2 gentlemen on my team that had very serious medical issues within the last couple of years since this event has happened. And she was the first person to stand up and do fundraisers for those 2 individuals and raise several $1,000s for both of them. Beyond that, Cindy does a great job making sure everyone at our facility feels welcome and takes care of everyone. Sometimes she should take care of herself better than that, but she is an awesome person.
Thank you, Mr. Flom. You may go have a seat in the back. Next individual, please. Please state your name, spell your name for the record, and your relation to Ms. Patra.
My name is Dale Bistram, DALEBISTRAM. And Cindy is a part-time casual labor employee for me, and she did work for me for about 3 years before she got hired at Parker. And I just got a 1-page letter here, if I could read that I wrote, just so I know what I'm saying here is.
If you're going to read something, please read it slowly
Okay.
and enunciate your words. My court reporter does need to take everything down.
Sure. Again, my name is Dale Bistram. And as of December 1st, I will have owned the Country Cafe in Grantsburg for 10 years. Between this restaurant and other private and corporate restaurants, I have been in the business for about 34 years. Most of that time has been in management, either managing corporate restaurants or my own. In those 34 years, I hired over 500 employees, so I would like to think I'm a pretty good judge of character. I first met Cindy Patra in 2018 when she came into my cafe to apply for a job for cooking. I interviewed her for about 10 minutes before I hired her on the spot. She worked for me for about 3 years before getting hired on at Parker full-time, which I understand because Parker could offer her benefits. Since then, Cindy has worked for me as casual labor. For instance, last Sunday, I had a cook that didn't feel well, so Cindy was at my cafe within 10 minutes and finished out the day cooking. I consider myself lucky to have someone like that can come in on weekends at a moment's notice and do a great job. My customers and my employees truly enjoy her. Cindy has also been there for me outside the cafe. For instance, when I needed help right after my dad passed away, Cindy was right there to help me with cleaning up around the farm, even going as far as jumping on the hay rack, stacking bales, only taking a couple bales for herself as compensation. There are a few people that I know that would do that. In the years that I've known Cindy, I have watched her grow in her professionalism, dedication, and integrity. From myself working at Parker, I still know many people there, including management, and I've never heard a bad word about her. As for my cafe, again, people enjoy her, being able to step in wherever and do what it takes to get the job done, making sure my customers get taken care of. Finally, may I be the first one to say Cindy is needed by me, Parker, and the community. I would ask that you allow Cindy to keep staying active in the community and to be able to still contribute to all that have become to know her and appreciate her. Thank you for listening.
Thank you, Mr. Bistrom. Next. Again, please state your name, spell your name, and your relationship to Ms. Patra.
Good afternoon. My name is Anthony Wolf, Anthony Wolf, and I'm the Assembly Supervisor at Parker and a co-worker of Cindy Patra. First and foremost, thank you, Honor, for allowing us the opportunity to speak on behalf of a co-worker as well as a friend. I have worked with Cindy for roughly 6 years now, and she has helped me at vital points outside of work as well as inside of work. There have been times where I've had broken down lawnmowers and she has graciously driven her own lawnmower to work to allow me to borrow. She is a pivotal person at work on our engagement team. Anytime that there are fundraisers or other raffles that we are putting together, Cindy is typically the person that is deciding which organization those funds and proceeds are going to. And just for me personally, 2 years ago, when my youngest was born, and my brother in Ohio passed away, and I didn't have a lot of funds. She was the first one to go around work and get enough money together for me to go to my brother's. Sorry. And I don't know that I'll ever be able to thank her enough for putting herself out in front of everybody to get that arranged. So that's just, I want everybody to know that she is the person that would take and give you the shirt off of her back in any situation, regardless of the circumstances. Thank you.
Thank you, Mr. Wolf. State your name, spell it, and your relationship with Ms. Patra.
Good afternoon. My name is Matthew Olson, Matthew I am the plant manager at Parker in Grantsburg and have had the privilege of being a coworker with Cindy for the past 5.5 years. What's really impressed me with Cindy is how much I've been able to see her grow in those 5.5 years. She started as an assembly operator and was able to get promoted to a brand new role within our organization. And it was a very open, undefined role, but she, while didn't have the skills to originally work the role, she took it upon herself to really learn those skills, computer skills, leadership skills, as well as manufacturing principles, to the point where she was able to lead others within our organization. She's counted on not just at our location, but several locations across our corporation. She does that through an incredible can-do attitude. She is one of the people that thinks about what we can do, not what we can't do. One of the most honest individuals that I have the privilege to work with. She is always able to share with us what we need to do differently and how to do things better. She's a great advocate for our team members on the shop floor. I will echo what others have said from the engagement standpoint. The involvement that our organization has within the community is a direct result of the initiatives that Cindy drives to make our community a better place, in addition to our work environment. The other thing I would really like to emphasize is we are an organization under tremendous growth right now, and she is a leader of our safety team. It's an organization of cross-functional team members within the manufacturing facility. She leads that organization exceptionally well, with a huge emphasis on how to make sure that all of our new team members are working safely. She leads the training and develops training initiatives to make sure people are working day in and day out in a safe basis, and really make sure that we continue to grow that culture within our organization. Like I said, it's been a privilege to work with Cindy these past 5.5 years. She's a great member of our community as well as our organization. Thank you.
All right, please state your name, spell it, and your relationship with Ms. Patra.
Okay. My name is Rochelle Hendren, Hendren. I am Cindy's sister. I'm hoping, I'm going to apologize, I'm a supportive crier. I'm hoping I do more good than harm. My whole life I've been with my sister, and it has been an absolute very rough time growing up with Cindy for a good part of her younger life, with drugs and alcohol and stuff like that. We didn't think that Cindy would make it this far in her life because of how reckless she has lived her life. But in the last, I'd say 15 years, Cindy has improved greatly from where she was. Her kids at one point didn't want anything to do with her. It has grown so much better as she's gotten older. I myself would not be a character witness for my sister if she was still on that path. I wouldn't spend my money to fly up here to be here for this if she was still that person. What she did back in December was not right, not the right thing to do. And I know in the last over a year and a half or almost 2 years now that she's been, going through this process with the decision she made that day has been extremely rough and extremely hard on her. And I know that she doesn't want this to happen again. And we say lots of prayers that she can get through this. She's a very strong individual. I too am very excited to see so many people stand up for her in her community. That is not a close friend, that is say like a drinking buddy or a party buddy or anything like that. Cindy doesn't live that life anymore. And I've been up here for the last 8 days and just see a total different person than I did when she was in a bad place. And I just know that I can guarantee you won't see Cindy here again. And if you do, you won't see me here again. I'm here to support her because she's done such wonderful things in these last 16 years. And I see that with her kids. I see that with with her community. Cindy has always been extremely helpful and giving. And even when she couldn't in the most difficult times, if it was her last dollar, she'd give it to you if you needed it more than her. So I hope I'm a good character witness, but she has come such a long way. And I'm very proud of you. And Mom and Dad would be proud too. Thank you. Thank you for your time.
One question.
Of
Because
course.
Your letter says you're from Golden Valley, Minnesota. Why would you?
Yep, we moved to Florida in December
Okay.
because it's warm there, very warm there.
Oh, you can fly from Golden Valley, but that, I guess.
Yeah. This way we have a permanent vacation down there now, so.
Sounds great. Thank you, Ms.
You can come
Hendren.
on back if you come down to Florida. Thank you, Your
Thank
Honor.
you. Argument and sentencing recommendation, Mr. Schmidt.
Thank you. We're asking the court to do the statutory minimum on this. I'll start first with the criminal history. It's largely duplicative of what Ms. Patraw's sister just described. Ms. Patraw had a pretty rough and tumble time in the 90s in Minnesota. Numerous convictions for lying to the police, for thievery style offenses, for possessing drugs. All of that stopped in the 2000s. Going from 2000 and onward, you'd only see driving without a license or her OWI-3 and her refusal. The 4 prior convictions being 2 from the 90s, actual drunk drivings, and then OWI-3 was in 2002 in Minnesota, Steele County, and then 2010 was a refusal breath test, which counts as the OWI-4 conviction here in Wisconsin. Meaning it's been 16 years since a countable conviction and 24 years since an actual drunk driving offense. In particular, I'll note that 2010 one did not even charge a drunk driving. So it's not like a read-in where they think it was drunk driving or could have shown drunk driving and resolved as the other. It was just a refusal. So in this case, Ms. Patraw's previous history is extremely distant. Even that 2010 refusal, which is her last criminal conviction, was 16 years ago. In Wisconsin, though, we take drunk driving very seriously once they get up in the high numbers. We count them differently than Minnesota, where in Minnesota, if they're just spaced out over a long period of time, you can avoid a felony OWI conviction forever. But in Wisconsin, we count back once you hit 2 or more all the way through your whole history. In this case, that makes a 5 in Wisconsin. That's a mandatory prison sentence. In this case, I think that's justified as well, in particular, just because the nature and circumstances of this one, someone could have really died here. It could have been Cindy Patraw herself if she just didn't have a seatbelt on, to be honest. But there are numerous other ways it could have gone wrong and that this didn't go worse than it did. So for those reasons, I'd ask the court to follow the agreement. Thank you.
All right. Mr. Benson, argument.
Thank you, Your Honor. I couldn't describe my client any better than the 5 people who came up in front of you today and said what a quality and character person she is now. A true value to the community, loved by everyone. I don't have many hearings where that many people come out in support of someone who's going to be incarcerated. To pick up on Mr. Schmidt's talk about how our state treats alcohol, I would say within the last 5 to 10 years, the legislature has really cracked down on alcohol. I think before that, it was more of a kind of a whatever thing. Wisconsin has a reputation for that, for better or for worse. Part of this sentence, though, and I think we touched on it even at the last hearing in this matter, is that section 346.65 sub 2 sub AM sub 5 says that there is the 18-month presumptive mandatory minimum, but it can be downgraded to 1 year if the sentencing court finds both that 1, the best interests of the community will be served, and 2, the public will not be harmed. The court may depart from the mandatory 18-month initial confinement term if it places its reasons on the record. And I'm pulling it from a case that I'm probably going to tank the name. It's State v. Shirikian.
Spell it, please.
Shirikian. It's a 2023 Court of Appeals case, 2023 WI App 13, 987 Northwest 2nd, 819.
I just want to stop you right here because I just want to make sure that you're in the confines of the agreement that you've reached with your argument. Is it free to argue, or is it a recommendation by both for the mandatory minimums?
I always phrase statutory minimum, and when I say that, I assume they can make this argument.
I just wanted to make sure that that was on the record.
Yes,
I don't view
didn't-
it as a breach of the plea agreement.
Yeah, I didn't think you would object. So
I just wanted to
Mhm.
make sure, Mr. Benson, so
Mhm.
we don't go down some other road.
no, I understand. I don't want to waste the court's time, but I do want to get a lot of things on
Not,
the
I want you to say all of those
Okay.
things.
Thank you, Your Honor. So, and in touching on her criminal record, obviously I'm not allowed to keep a copy of the criminal record, but Mr. Schmidt again was right. In reviewing her driving record, the last conviction is February 28th, 2011 from the 2010 case. And I went through Minnesota's version of CCAP and pulled a lot of paperwork out of there, to be honest. But the last thing you'll find there criminally is from 2010. So, and as her sister indicated, it was rough growing up. But I think 15 years ago, the light went on. Some people enter adulthood later than others. And for Cindy, it just happened to be about 15, 16 years ago, I would say. She has done the AODA. They didn't recommend any further classes or anything like that. She has an online support group all over the country where they share each other's burdens and things like that. And I think it works out really well for her. She even completed her driver's safety plan July 31st last year. So she certainly is taking this seriously. When she and I talked on the phone this morning, because I thought she was having medical issues, she said, no, people are coming today. We're going to do this today. I'm going to finish this today. And I hope when she speaks to the court, she can tell it to you like she told it to me. I said, that is perfect. That's exactly how you should address the judge. But when you're looking at this best interest of the community, first of all, does she need punishment or does she need rehabilitation? She really hasn't done anything criminally for 15 or 16 years. And again, it is a 5-6 OWI. It's serious, and Wisconsin takes that serious. And she knows she's going to be remanded into custody today, and she knows that the bare minimum would be 1 year in state prison. And it's made her very emotional, but again, she's here taking responsibility, and she's showing the court what she's done in the last 15 years that makes her a credit to the community. Is the public safety endangered? If she were to drive again, certainly that risk would be there, I think. But to my knowledge, she will never have a driver's license again. This is more of a once-off than a pattern, I would argue. Were you to give her less time, would that cheapen what the law is intended to do with 1.5 years? I don't think it is. I don't know how many people come in front of you for sentencing like this, but I bet they don't have the support that my client does. And again, it is a very serious crime. However, I think what she's done and what she can do would mitigate the 1.5 years to look more towards the 1 year. And she understands there will be extended supervision as well. This crime involved alcohol. She used to have a bad prior record, but she doesn't any longer. Would serving less than 1.5 years and serving the year allow her to return safely to society? I think 1 year would be imperative. I think that would work for her. I think these people are chomping at the bit to get her back. I don't think they said there's a job waiting for her, but I'd be willing to bet that when she gets out, she'd be working at Parker again. And since this stop back in December of 24, she's done everything she's had to do. AODA, again, the driver safety plan. She showed up at work. She showed up for every court hearing. She's taking this seriously. And again, she knows that she's going to have to report to the jail immediately or a deputy will be coming in. So that said, Your Honor, I'm asking the court to look more towards the 1 year instead of the 1.5 years. Thank you.
Thank you, Mr. Benson. Ms. Patra, I'm now going to ask you if you wish to make a statement here today. You do not have to. It's your choice. I see that you do have something in front of you, and I'm going to assume that it's the letter that I have read. Please, if you are reading the letter, go slowly and enunciate your words. And if you are having an emotional time, because this is an emotional hearing, please stop and take a breath before you begin again. It's hard for my court reporter to be able to take down things when they're muffled, okay?
Yes, Your Honor. Have to start my name?
No.
Okay. Before I even go to the letter, I just want to apologize for being here and for being here, taking up your time. I want to apologize to my family for putting them through this. I want to apologize to all my friends and my employers for putting them through this and what it's doing. It's gonna make things difficult, and I'm sorry. I want you to know that this is not me. I did have a hard life growing up, and I was addicted to drugs for, I'm gonna say, over half my life. And my daughter's not here right now because she had to work. But my daughter's, I give her the most credit for me coming to who I am now, because I love my grandkids to death. And she basically told me, either change your life or you'll never see your grandkids again. Well, they were worth it, you know. And it's the best thing that's ever happened to me. I realized that I'm not just that person that came from the hood or Frogtown or whatever you want to call it. I can be more than that. Don't have to be defined by where I came from. And I thank Parker for giving me the opportunity to prove that. And I'm more than that. And for my friends and family for being here to support me, I want to say thank you. I also want to apologize about the accident. And you're right, prosecutor, you're right. I could have killed myself or somebody else, and I do understand that, and I really apologize for that. My son drove by the spot where the accident was, and he has nightmares about it, thinking I was dead. I'm sorry to put you through that, Max. I love you. And I'm sorry that's stuck in your head. I'm going to try to read this letter. Dear Judge Mogen and counsel, I am writing this letter to express my deepest remorse for the mistake I made. That brought me before you. I fully accept responsibility for my actions and the consequences that have followed. I want to sincerely apologize to the court and to everybody affected by my behavior, to the community. I understand the seriousness of what I did, and I'm truly sorry.
Ms. Patra, you can stop and take a breath. I have read your letter. I did read it very carefully when I read the other letters. If you wish to continue to state it on the record, you may do so. But I rest assured, I did read your letter.
Thank you, Your Honor.
Want to say anything else? Do you want to read it?
I can't. I just want to say I'm sorry. And I wish there was a way that I could be on a bracelet and turn myself in every weekend and go to work and make sure I take care of my family and my responsibilities.
Ms. Patra, what happened that night?
I worked 18 days in a row, and one of them I worked at the cafe during the day, and then I went to Parker at night to do something before Monday morning and get that done. And then the next day we had a bake sale. And so I stayed late for the bake sale, and I left work, and it's Christmas time and people from out of town were in town, and they were downtown. And I said, well, you should stop by. And I was like, okay, well, stop for one. So I thought, and I don't know if you've heard a lot about the drink was a lot stronger than what it probably should have been, what I should have been, I think. But I stopped and I got there, and the people that I was there to meet, I noticed had already had too many, and I had a drink sitting in front of me, and I told them they needed to leave. And so I finished my drink, and I turned around, was talking to somebody, and I turned around and they had filled it again. So I said that was gone, and then I left. It was snowing out pretty bad. It was like the roads were slick. It was blizzard kind of conditions. And honestly, after the accident, I hit my head because my airbag didn't work. And I honestly do not remember anything from there. I tried to get video because part of me felt like the truck that I hit may have came out of the T-Dog's parking lot. You know, I don't know it for sure because I don't recall seeing it. I mean, I don't have very good eyes either. Matter of fact, they told me next time I go to get my license that I better go to the eye doctor first. But and it was an accident. I never in the world would set up to do something like that. And I would honestly tell you, this thing I went to, the lady down here at Aurora.
Take a breath.
The lady at Aurora. So I see people do it all the time. They have a drink or two and then they go home, you know, and it happens. Like I used to have waitressed in restaurants and bars, and I see it, and I never thought in a million years that I could have a couple drinks and be over the legal limit. I really never did. But she told me, she said, no, it's meant that way. She goes, you're meant to be over the legal limit after one drink. And I was like, what? And being naive is no excuse. And I know that. And if I could do it all again, it would never happen. You know, I just wish I could do it over.
Thank you, Ms. Patra. And you understand that your legal limit is different than other individuals' legal limit.
No, I didn't understand that either until just recently.
Yes, your legal limit is 0.02.
Yeah, I didn't know that.
It's because of the number of OWI, DWI convictions you had. And so your legal limit is 0.02. So the Aurora individual was correct. One drink puts you over the limit.
I didn't. And being naive is not an excuse. And I know it's not an excuse. But
however, you did, your blood alcohol content was 0.115.
Mm-hmm.
So that is over the 0.08.
Right. It's still over the legal limit. I understand. And I just wish I could do it over. I never in a million years. I'm the guy trying to tell the other guy that he's had too much to drink. He should probably go home. You know, I've never seen this guy. I swear to God, years ago, after being in jail, that I would never be here again. And I can't really believe I'm here now.
Right. Ms. Patra, I do have to say that it is very commendable that I see so many people here supporting you. And I've heard so many words of genuine care and concern and respect. I don't see that a lot. I don't see it a lot with evidence. I don't see it a lot in many of my cases, regardless. So it is very good to see these individuals behind you and who will continue to stay behind you. In sentencing an individual, Ms. Patow, the court has to look at a few things. I have to look at first the nature and the gravity of the offense. How serious is this matter? Then I have to look at the character of the person in front of me. And that would be your schooling, your education, the jobs that you've performed, how you are in society and what you do. I have to look at your criminal history. I also then have to look at the need to protect the public. All right.
Yes.
And I have to look at if you are a threat to the public. And then I put it all together and I weigh it all out to determine what a sentence is. What a sentence is for you is different than a sentence for a different defendant, because the court has to look at all of those specific things. This is a case where the court cannot look at probation first, because this is a mandatory minimum prison sentence. The court is told by the legislature in our laws the mandatory minimum, with that caveat that Mr. Benson did go through with the case law. This is a very, very serious matter. Even if the court doesn't look at the 0.02 level, the blood alcohol level, it's still a 0.115. That's still almost double the legal limit in Wisconsin for a person who is not under the 0.02 requirement. So that makes it serious. The second part that makes it serious is the fact that there was an accident. You are so lucky to be alive here today.
Yes, Your Honor.
Mr. Schmidt hit it right on the head when he said that someone could have died or been seriously injured from this accident. But for the grace of God, you are here and no one was hurt. You were hurt, but you were able to recover to the best of your ability. I'm really glad to hear the statement from Mr. Benson in which he said he thought you were going through medical issues right now or needed something medically, but you told him, no, I want to move forward today. I want to accept the responsibility. I want to be accountable. I don't want to delay. That takes a lot of courage, Ms. Patow. It's not easy to sit in your seat knowing that prison is your next door. I just can't even imagine what that feels like. But I am seeing a person who made a mistake. Well, you made a mistake, but you want to change yourself and to change that type of conduct so you never do it again. From hearing your statement, Ms. Patow, it sounds like not only are you a giving person, and that's the statement from everybody, you are a giving person, but you are an over-giving person. You give to everyone else and you empty your cup. You need to have time to have self-care, to replenish yourself so that you can be the best for all the people you serve. I'm not going to say I have not been in your shoes in having the weight of the world on my shoulders and having a drink or two. You have to make a different choice and not get behind the wheel. Unfortunately, you were not aware of the 0.02 blood alcohol content. However, you are aware now. And in Wisconsin, an OWI fourth offense is a felony, and that makes it a lifetime restriction on your ability to drive. The Department of Motor Vehicles will determine that, You're going to hear me say that you're revoked for a period of time and you have an ignition interlock device. I'm still required to say those things on the record. It's the Department of Motor Vehicles who will be in charge of whether or not your license is revoked for life. Okay?
Yes, Your Honor.
In protecting the public, I look at you and I look at a person who is very giving and out there for the public, for the community. But for this one time, but for this action, this day where you were overworked, you were tired, you were exhausted, and you wanted to let loose or relax. You weren't at the bar pounding them one at a time, one after another after another. You had a few drinks. I'm going to guess that they were hard alcohol by the way you've spoken about the drinks, and it hits harder. I have so many people here that are supporting you today. And I'm going to guess that if given the opportunity or the necessity, I would have a courtroom full times 10. Because it sounds like you're not only generous to each of the individuals within this courtroom, well, behind those walls in the gallery, but you are giving to a whole lot more people who would sit there and give more positive statements. I'm going to tell you, I bet I could have had 50 or 60 written statements for individuals wanting to make positive remarks about you. That goes a long way, Ms. Patroff. I'm sure you've heard, and others in this courtroom observing, I'm a judge that ensures that there is the punishment that's necessary, but I can look at the whole picture. I know I can be harsh, Ms. Patroff. Rest assured, it is not easy sitting in this seat knowing that I am sending somebody to prison and for how long. Even sending an individual who has done bad things is difficult to do sometimes. I have thought about this from hearing from the members of the community and from hearing the argument from the state and from the plea from your attorney. And honestly, I'm glad your attorney went down that road because that was already going down in my thoughts. Ms. Patra, here's what I'm going to do. I don't do this often. It is rare for me to go down this path. It is rare for me not to follow the law to the best of my ability as I understand it. The legislature has mandatory minimums. It's kind of a battle for me to not follow mandatory minimums. I think I've only done this once, maybe twice. Ms. Patra, I'm going to sentence you to 1 year in prison with 3 years of extended supervision. I am not following the mandatory minimum of 1.5 years of initial incarceration. And here's why, because I have to state that all on the record. On top of everything that I have done here today, I find that it would be in the best interest of the community, and the community would be best served with you out in the community, doing the good things and continuing that. I do not believe that the public would be harmed or that I am spitting on the law by not following the mandatory minimum. I believe that in fact, the public could benefit once you come back into the community. But here is what I am requiring because of this sentence. I am requiring that you, once you are released from custody, you will be in my treatment court.
Sure.
And that is why, that is the tip that has tipped it over for me to do a lesser sentence than the mandatory minimum. The treatment court is a lot of work. You have a lot to do, a lot of requirements. You're one step ahead because I'm going to guess you have a place to live and I'm going to guess you're going to have a job coming back. But you're going to need time to come to treatment court, to do meetings and to do other things. And you know what? I believe that you could benefit from that. I also believe my treatment court can benefit from you. So again, that's where you're going to be giving back to the community.
Sure.
You will be a positive influence for the individuals that I have in my court. And I want to tell you how rare this is for me to do this. I am assessing $3,464 in fines and fees, plus a $10 blood draw fee. There's $750 in restitution. Is that stipulated to, Mr. Benson?
Yes, Your Honor.
Plus $750 in restitution. I believe I said 3 years of extended supervision, 3 years revocation of your driver's license, 3 years of ignition interlock device. I do have to continue to order that you do the OWI AODA assessment and follow through. The statute still requires me to say those things. Now, while you were on extended supervision, well, let me go back. While you're incarcerated for the year in prison, you cannot engage in any early release programming. If you are revoked off of your extended supervision, you may engage in early release programming on that additional 3 years that will hang over your head. While on extended supervision, treatment court, absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia. I don't know. I don't think that that's what you're involved in, but it was in your history, so that's why I'm saying it. Testing, gainful employment. I don't think I have to order community service. I think you already do it. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. This is a felony. No use or possession of a firearm for life. No voting in any election until your civil rights are restored. I do need to order your DNA. The jail will make sure that they get that once you report. This is an immediate report. After you're done here at this hearing, you must immediately go to the jail to the day reporting to get booked in. And then you will go to jail and then they will send you to prison. With regards to the amount that you owe, the court ordered restitution, surcharges, and costs, and the fines, they will be collected as a percentage determined by the Department of Corrections to be reasonable while you are in state prison. They are a condition of your extended supervision, so you must make payments. Whatever the Department of Corrections deems reasonable while you are incarcerated is that number that you will pay or have to pay. Once you are released from custody, the court is going to order that you make payments of $300 per month. All right, $300 per month once you are released from custody. Once you're released from custody, you must immediately you will be told to go to your probation agent. They will set you up with treatment court, and then you will get that ball rolling. On the
Scott
record,
Lang.
in the matter 26 CF 28, State of Wisconsin versus Gary Fetzich. The state appears through Assistant District Attorney, or excuse me, through District Attorney Kevin Schmidt in person. Mr. Fetzich appears in person with Counsel Bruce Anderson. We're set today in this matter for a status conference. Mr. Anderson, please update the court.
Well, as the court can see, Mr. Fetzich is here today. He advises me he has another surgery, which will be about his third or fourth in the past couple of months, coming up the 27th of August. We have really come to the conclusion that he wants to have a trial in this matter. Matter is going to be timing. He hopes to be healthy after this latest surgery. They're removing a foreign object that was left in his abdomen during one of the last surgeries. So.
Do we have the lab analyst?
Yeah.
Mr. Anderson, would you think it would be 1 day or 2?
It's felony with an analyst. Thinking of even picking a jury for a felony case is a little bit more intense than otherwise.
Not here.
Pardon me?
Not here. We pick them pretty quick.
Yeah, but you've got more to get for a 12 person.
I don't know why it would be different. The elements are the same.
What's
Well,
that?
he's saying versus a 6-person jury.
It's one of the crime labs. It's Wausau. It's the Wausau Crime Lab. The number for that one ends in 8626, the phone number. And the analyst for this one is Lexus Hagedorn.
Lexus. Off record for scheduling.
Crime Lab, Alexia speaking.
Hi, this is Judge Mogen in Burnett County. I need to schedule with Lexus Hagedorn an OWI jury trial.
Okay. And what date did you want to schedule it for?
Well, let's just see if first I have to see with the attorneys. November 2nd and 3rd.
It looks like you'd be number 1 both days.
Does that work?
Yeah.
All right, November 2nd and 3rd.
Okay. Do you have our lab case number?
Yes.
Mr. Schmidt, the district attorney will tell you that.
It is CL26-01090.
Okay. And what's the court case number?
26 CF28, State of Wisconsin versus Gary Fetzich.
All right. And we'll get that on our calendar for November 2nd and 3rd then.
All right, thank you so much.
You're welcome. Have a good day.
You too.
Bye.
Back on the record, same appearances as previously noted. The court has scheduled a number 1 jury trial with lab analyst Lexus Hagedorn for November 2nd and 3rd. We need to set a final pre-trial. Mr. Fetzich, that is the court's drop dead date where any agreement must be reached before that date and time. Otherwise, the state would need to dismiss in entirety, or you would plead guilty to the charges. October 5th at 10:30.
I'm scheduled in Shell Lake.
October 7 at 9.
Works.
All right, you can come up here and get your notice and then you're free to go. Thank you.
Oh, what was the jury trial date?
11, 2, and 3.
11, 2, and 3.
Mr. Anderson, do you have other clients?
I do.
Oh, yes, you do. Natasha. We will go on the record in the matter 26 CF 25, 25 CT 52, State of Wisconsin versus Natasha Mansfield. The state appears through District Attorney Kevin Schmidt in person. Ms. Mansfield appears in person with counsel Bruce Anderson. We're set today in this matter for status conference. Mr. Anderson, please update the court.
Your Honor, as the court may recall, my client was turned down for the IDIP program because of prior involvement. It appears as if she will be, if accepted by treatment court, that will work. I guess we have to apply at this point and see if she's accepted.
I believe she has and she is.
Oh, that got through. I wasn't aware of that. Okay.
If things go and if it reaches resolution, she would qualify.
And for your drug court, you have to have a plea to get her into drug court. So,
Yes.
Yes. Yeah, we intend to do that. Yes. So I guess we can schedule a plea hearing.
All right. Available September 9th at 2:45.
Doesn't sound good. Trying a case in Balsam Lake before Judge Yackel. For 3 days.
Wow, that's a long one. Would be scheduled on an ADA week, September 3rd, if it works for Mr. Anderson.
Chair Judge.
Mr. Anderson, can you do either morning or afternoon after 1:30?
I can only do the morning prior to maybe like 9:30.
We can do 9:30.
Is there a different time that day?
Is that public safety?
Yes.
How about September 4 at 9?
Works for me.
All right, September 4th at 9 a.m. We'll see you then. Come and get your notice and you're free to leave.
In this hearing, Judge Stephanie Thomas Schmidt ultimately grants the request to extend Shannon Tretzman's purge conditions for another year. The court acknowledges that while the child support obligation remains serious, the defendant has shown some effort toward making payments and needs to take additional legal steps if he wants his support amount reviewed. The judge explains that the responsibility is on him to file the proper modification request and provide the necessary financial information. The ruling gives him additional time to comply while keeping the court's expectations clear. This case highlights an important part of the justice system, balancing enforcement of court orders with opportunities for individuals to correct their situation. The outcome shows that accountability and second chances can exist together when the court sees a path toward compliance. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.